Alex here with part 121 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So we are going into my reply to my ex's opposition to my motion to modify child support. My reply, I'm sure, is just going to grapple with the willful underemployment angle that she's putting forth. I've already talked a lot about this in my previous videos, but I know that my mindset was very frustrated because it didn't feel fair. And this isn't the first time my ex's attorney has done this. And what I'm trying to say is that in the past, when child support came up, my ex had issues where I could have sworn around the 2008 economic decline, she was not furloughed completely, but I think she was working like one less day or something like that. This was what the federal government was doing back then, and I never raised the argument of willful underemployment. I just said, okay, well, you're underemployed for reasons that have nothing to do with your own will. You know, it's the government doing that. And here I was going to school, same thing. Somebody mentioned in a comment, and this is actually a great point, that person mentioned that some people go to school just to lower their child support and they don't actually really intend to graduate, or if they do graduate, it's not really going to increase their income. This is actually very true. And I don't think that just because you're going to school, should the court automatically assume that you're not trying to avoid child support. I still think that there should be some kind of fact finding, but at the same time, just because that I understand this is a possibility and that this probably does happen in cases, doesn't mean that it happened in this one, and it also doesn't mean that the judge based his decision on it. So if the judge said, I think you're going to school, but I don't think you're trying to graduate, or I think you're going to school, but you're not trying to increase your income. If he made a finding like that, I would probably be annoyed for other reasons, but I wouldn't find him to have made an egregious mistake. I would have just said, you know what? He looked at my evidence and he disagreed with me. You know, he's entitled to deference on the facts. I can understand this. I'm upset because it's not true, but I can actually make some sense of it. But he doesn't say that at all. He just says something along the lines of, well, if you're going to school, that's your choice to do that and you have to pay for it. And you guys will get to see this at a hearing, which is one of the things I love about My Docket series. I actually put all the hearing videos up so you guys get to see that I'm not just, you know, saying stuff. It's actually going to come up at that hearing. You're actually going to hear the judge say that. And that's where my anger and that's where my finding his decision to be egregious comes from, because he doesn't say what that other viewer said. Also, you'll notice that there are several things that I did that I think a lot of other parents won't do. So I attached an affidavit from my boss stating clearly that I was working the amount of hours that she was able to, you know, budget for. And then I could have sworn that I produced an affidavit from the professor, but I don't, or, you know, you have a number of professors, but I could have sworn that I produced at least one affidavit from my professor. If it hasn't come up in the My Docket series yet, it will come up. You'll get to see that filed. So this isn't a situation where I go to court, and also the transcripts. So I'm producing my paychecks, I'm producing an affidavit from my boss, I'm producing the transcripts, I'm producing all of these things that I think a lot of other parents wouldn't do. I think that a lot of parents would say, hey, Your Honor, please just trust me. And I'm here trying to give them as much evidence as possible. And that's why I am so upset. And I think that's another thing that upsets parents. I mean, there's one thing to just kind of wing it, not care, and not do any work and lose. And it's another thing to have done so much work for the judge, to have gone and gathered so much evidence, and then for the judge to just say, nah, don't care, you lost. Again, there are normal situations where this occurs, but we're talking about a situation, and I guess I should go into that a little bit. Normal situations where it might occur might be a situation where both sides are presenting evidence and they go to court on equal footing. And they are, maybe one side wants money damages and they're both producing photographs and video evidence and stuff like that. But this isn't that situation. This is a situation that's really niche. This is a situation where Somebody's trying to say you're willfully underemployed, and so the issues that the court is looking at aren't all that broad. The court isn't looking at the whole entire case from beginning to end. The court is only looking for very specific things, like what's your paycheck, where are your transcripts, and what do your professors and employer have to say. And again, all that being said, even with these niche issues, the court could have actually conducted the correct analysis, and the court could have said, yeah, I've looked at your evidence, and under this, under certain circumstances, you wouldn't be imputed for going to school. But having reviewed your evidence, I'm going to make a finding that you are going to school to fake like you're trying to grad. I mean, all those things, he could have gone that route. He could have said those things, and for other reasons, I would be annoyed. But at least I could see how it fits into the law. At least it wouldn't feel like, number one, he didn't even read the law. And number two, if he did read the law, he just decided he doesn't care and he just does whatever he wants. He just, they call this a law unto yourself or a law unto himself. A judge is supposed to adhere to the statutes that the legislature enacts, and a judge is supposed to comply with the precedent that the Supreme Court sets forth. Part of that job means doing research to find out what those statutes are and to find out what that case law says. And to just plop down on the bench and just be like, I'm just going to do whatever I want to do because I just feel like doing it, because my opinion is that this is how it should work. And to just take all those statutes, crumple them up, throw them away, to take all that case law, light it, with a match, burn it, throw it in the fireplace, and to just do whatever you feel like doing, that's not what this country was founded on. So I think this kind of went a lot into my mindset, but I think that this really, number one, will elaborate on that one particular viewer who posted a comment, because the point he made is very valid. That's absolutely a possibility in a high conflict child custody case. That can happen. And number two, I still needed to sort of attack the approach that my judge took with this issue, which is to just not care about the law and to just come up with his own opinions and to rule from the bench based on just how he felt that, things should work. Again, I think you guys are going to get a much, much more accurate depiction as to what happens when we get to the hearing video, which we will get to. We're not there yet. But may as well do what we're supposed to do in this video, which is to go ahead and take a look at what I have filed. Here we have my reply to opposition to motion to modify child support. First paragraph, standard introductory. I identify myself to the court, indicate I'm appearing a proper person, which means I don't have an attorney, and state that I'm filing a reply to my ex's opposition to motion to modify child support. I don't put the date down as to when she filed the opposition, just a pointer for you guys to probably do that. Going into the first assertion here, which is that my ex mischaracterizes my apparent underemployment. So the reduction in income is only partially to blame on a reduction in workable hours, the original basis for the order for support. Okay, I see what I'm saying here. So she's trying to make it seem like my income has gone down because the number of hours has gone down, but it's not true. It was also the fact that I was getting commission at the previous job. In fact, that was probably the bulk of the decrease. I think there was something like a 40% decrease in my wages. Maybe 20% was because of hours at most, but the other half of it, that had to be the commission payments, because it was substantial commission. Most of that job paid out in commission, not in hourly wages. So this is something that I don't have a 100% clear memory on, so maybe there is something that comes up at the hearing where we actually go through the numbers. I'm not sure now if this happens. But anyway, I just wanted to mention to you guys that it wasn't just the reduction in hours, it's also the commission. Okay, let's take a look here. So my ex claims that I should seek employment in some legal capacity or in web design or other positions. Yeah, you can't do that. Anyway, okay, you could possibly get some of those jobs without a degree, but it's not going to be a serious job. The major companies want you to have a degree. They're not just going to take somebody off the street. Again, there are some exceptions to this, some very small businesses possibly, but they're not going to pay what an actual full-blown corporation that hires software engineers is going to pay. So I do mention here that I did do some odd jobs building websites, but that, this isn't a full-time thing. This is really, I think, one of the reasons why people who go through family court cannot stand the lawyers. It's because this isn't a situation where somebody claims an injury and they want to get paid back for it, like a car accident occurred, or destroyed parts of a home and there's like a landlord tenant situation. This is a situation where people are trying to live their lives, and the issues that come before the court have to do with trying to live your life, your job, the amount of money you make, your kids. These things are so fundamental to not just being an American, but to being a human being. And so when these attorneys use these conniving, dirty tactics, people don't forget that. And people come out on the other end of the system loathing attorneys. And I would wonder how many of those jokes and how much attorney hatred is from the family court system versus the system in general. I would say way more than half, probably between 70 and 90% of the hatred that society has towards the legal profession is directly connected to child custody and divorce actions. And so this is the kind of stuff that makes people angry, because a lot of people, they try and do the right thing. Not everyone. There's always, there's people out there who aren't nice. Most people, I think, try and do the right thing. And when they go into court and they try and convey, this is what my job situation is, this is what my school situation is, this is how my children are doing, and to have the other attorney just not care at all about the truth and to use the win-at-all-cost tactics, which again makes sense for ordinary types of lawsuits, but things get dicey when kids are involved. That's something that I think really not just exacerbates, but it's probably the source of society's hatred towards the legal profession. So anyway, this is the situation here. The problem is multifaceted. We have an economy in decline. We have my hours changing. We have a completely different industry. We have the fact that I don't have a degree. We have going from commission pay to non-commission pay. There's all of these situations going on. And then on top of all of that, the attorney that my ex has will constantly use inconsistent positions. So earlier on in the case, my ex has the right to know where I live. Here we are now in the case, parents don't have a right to know where each other's child is. They can totally keep their address secret. This is just normal. Any parent can do this. Same thing here. My ex has issues with her employment and her income is set at the hours she's working. But now when I'm working, all of a sudden I have to work 40 hours a week. It's almost like the attorneys have multiple personality disorder. In reality, the attorneys themselves probably don't care or concern themselves with the positions that they've asserted in the past. I have this feeling, especially, given my video, Wing It Lawyers, that most lawyers just remember what's going on right now. They show up to court, they talk to you, and the situation is what the situation is right then and there. And it's that they just can't seem to connect the past to what's going on right now, most likely because they don't care and also because they don't remember. And so that's where I think these inconsistent positions come from these attorneys, where, what's going on right now, use everything that I can right now, screw the truth, screw the person, who cares about any of this stuff, just bring up the stuff that's going to make this particular client win. And this is all of these things, I think, combine into the animosity that most average people that go through the legal system have towards the attorneys and the courts and all that. A lot of people, I think, put a lot of effort into their reputation, how they carry themselves, and the choices that they make. And then they go through a system that puts hardly any effort or attention into any of those things, slaps a few labels on them, shoves them out on the other side, and then bills them for it. So anyway, this is the situation that's going on right now, where I'm trying to correct all of these. I guess I titled it pretty well. I said my ex's attorney's mischaracterizing the situation. I'm trying to correct and bring some accuracy to what's going on. And this is where I think most of my anxiety came from, at least at the time. And this is also where most of my distrust of both the attorney and judge comes from. I'm going to go ahead and move on into the next section here. So I mentioned that I've been seeking alternative employment in the legal system. Oh gosh, and I'm even You know what's even crazier is the attorney is saying he should get a job working with computers, and it's like, I'm trying to do that. I'm going to school and I'm going to graduate next year. You know, it's like, not only is she saying things that make no sense, but I'm actually doing those things right now as we speak. In any event, let's continue. I mentioned that I'm seeking alternative employment, and let's see, the court shouldn't be blind to the fact that there are perils in changing employment. That's true. You can't just leave a company and go to another one, because next thing you know, it doesn't work out. You get laid off, you get fired, you have to quit because the situation isn't what you thought it was. And now, guess what? Now you're willfully underemployed again. So you have an attorney here who's saying, get another job, get a better job, work in a different field, make more money. And I could totally do any of those things, lose the new job, and then that attorney will say, hey, he shouldn't have left that other job. It was stable. He shouldn't have left and tried to work in that other field. It's like, they literally don't seem to have an opinion. It's whatever they need to say to win. It's, once again, going back to win at all cost lawyering, which I cover in a video. It's what they say has really very little to do with what they personally think and feel. They just look at the case, find out what's going to do the most damage to you, or what's going to dupe the judge most successfully, and then that's what they use. Anyway, there's what I'm trying to say, guys, is there's multiple different angles to these assertions that my ex's lawyer is making, and that she really doesn't care about any of that. And I could totally do what she's suggesting, and then in an alternate reality, I'm getting pilloried for doing that exact thing. So in any event, guys, this situation obviously didn't occur. I stuck with the job that I had, but I'm just letting you guys know that you could be in a situation like this where your opponent's attorney is telling you that you should get a better job or something like that, and then you actually go and do that, and then you end up back in court anyway because they say you shouldn't have got a better job. Now it's your fault that you got laid off or whatever. I don't know. This is just the terrible situation that is high conflict child custody, and this is a video that I wouldn't have thought I would have had so much of an opinion on, and here I am going into all these different tangents. In any event, let's go on. So this is basically all that stuff that I just said is covered in this giant paragraph here. I'm going to move on. So we got statutory construction and legislative intent, and here I am citing the law and the Miniart case, which I've discussed in a previous video. I'm not going to repeat it now. Here I am mentioning that an additional finding is required before you can impute income. This is something that the judge literally does not care about. Moving on, and here I am talking about getting my degree in computer science and how it's going to affect my child positively. This is an obvious thing. Not only is it obvious in principle, it's obvious in reality because I did graduate and I did greatly increase my income. And then the conclusion. So we move now into my verification, which is swearing under penalty of perjury that all the facts alleged in this document are true and correct. We go into the Rule 5 Certificate of Service, which is indicating to the court that I served this document to my ex's attorney personally by taking it to her law office. We have a list of exhibits and an affidavit. So this, I don't think I've gone over this yet. So let's go ahead and go through this. Exhibit 1. This is an affidavit from the attorney that I had in this case prior. I'm going to skip over numbers 1 and 2 because these are standard assertions that I put in an affidavit. So number 3, we have the fact that I previously worked with this attorney in the legal industry, that I and her were colleagues at a law firm, that I have always expressed a desire to better my employment, that I asked her for job leads all the time, and that I even handed her a copy of my resume. And then my last assertion is that I've expressed a sincere and genuine desire to better my education. That's great. Judge doesn't care. Moving on, we got my request for submission here, which is, guys, rather than talk about this again, I'm going to just direct you to my video, request for submission. I've gone over this like 20 times, and it's just one of those documents you're going to see over and over again in this case. Next document here is the order to file financial disclosures. This is filed by the judge, and he is, let's see, first paragraph is usually a standard summary paragraph. He has reviewed my motion to modify child support, my ex's opposition thereto, my reply thereto, and he is going to find that we share a common minor child, the date of birth of the child, the fact that we share joint legal, joint physical custody. Next assertion is that regarding child support, and he goes into not just the numbers, not just the amount of child support, but also the numbers that were used in the computation. Next assertion is that in my current motion, I claim that I was working full-time, and now that because the firm was dissolved and or sued, that I obtained work at a new job as a part-time paralegal. Okay, I'm taking advantage of working part-time to increase my enrollment from part-time to 3/4 time. I'm expecting to earn a degree, which I did earn exactly when I said I would earn it too. It's like, for some reason, I mean, I was gonna say it's like he thinks I'm a liar, but I don't even think he thinks. I'm not sure that he goes that far into his analysis. He just has these feelings and he just blurts out his opinion, and that just magically becomes his order. I'm really looking forward to showing you guys this hearing that's coming up, because you're gonna see exactly what I'm talking about. Here we have that my contention is my income decreased by more than 20%, and a review of modification of child support is appropriate. It's not just appropriate, it's mandatory. Here we have my ex's opposition asserting that I'm willfully underemployed. Here we have my argument that if I want to pursue school, I could do so by taking online courses. Oh, no, you can't. It's like she doesn't even do any research. She doesn't even try to find out if things are true. She's almost as bad as the judge. She just blurts out these inane statements without checking into any of it. Online classes, night classes, weekend classes, these are not available for a computer science and engineering degree once you get to levels 300 and higher. At UNR, you might possibly get these kinds of opportunities if you're going to school for nursing or for like education to be a teacher. If you're going to school for computer science and engineering, there may be some exceptions if you are in your 100 level classes. So like your very, very low level classes. But once you hit 300, 400 level classes, no, you can't do this. There's no weekend classes. There is no night classes. There are no online courses. This doesn't exist. None of this exists. And I just can't get my head around why they just say, and the judge almost buys it, because I remember he brings it up at, oh, this is like, you know, as a society, we think that these people are professionals, and these judges especially, and they aren't anywhere near that. And they don't even know how to do things that the most average person can do. These are basic research skills. These don't even take researching statutes, rules, and case law. You could Google UNR. You could call the school. They don't do any of these things. And it comes up in court, and I have to actually point out my affidavit that a professor... I went and I did all this work to do the research for them, and I bring an affidavit from a professor, and then all he does is change his mind. He's like, oh, okay, never mind. Apparently you can't do any of these things. Well, since it's your choice to go to school, you're screwed anyway, and I'm going to impute your income. This is just, like, sometimes I wonder why I did what I did when I started this channel, and why I did what I did when I started Our Nevada Judges. And then I have a lot of ideas, and then I go through one of these videos, and I'm like, now I know why I did it. Because all of these memories are so fuzzy. And then I go through this document, and it's like they come rushing back into me, and I'm like, now I know, now I remember, now it all makes sense to me. Now, I mean, it's just, again, I mean, I think any normal person is okay with a situation being almost what they thought it was. I think what upsets us as people, as ordinary people in society, is when we go through these systems and they're not even close to what we thought they were. They're like 25 miles completely off course. And so it's like we get totally, I don't know, I mean, this is a situation that I keep talking about that I'm just going to have to be patient and wait for the video to show you guys the hearing video, because that's where I think it's going to really connect with all of you, to actually see the judge and the attorney saying these nonsensical things. You just have to see it for yourself. Let's move on. We have here, in my reply, I claim that my current income as a paralegal / debt collector is commission-based. Even if it were imputed, I would still have a significant reduction in income anyway. I claim, you know, and here, like this, like there's so many things. It's not even just one or two things. They've got like a dozen things wrong. I like, if you want to know how possible it is for a person without a degree to go and get a job at like a professional software development company, it wouldn't even take that much effort to find out that they don't just hire random people. Like, this is another thing that is common knowledge. This is so basic. And for them to think, I mean, I don't know if the judges bought this lie, but for the attorney to even say that. Okay, moving on. We have my claim that I have been seeking alternative employment in the legal system. My claim of the perils of changing employment prevent me from leaving my current job for another. Of course, you have to weigh these things. He claims that he cannot go to school in order to avoid paying support. So here he cites the law. The judge says he cannot modify a child support order if the predicate facts upon which the court issued the order are substantially unchanged. He cites Local Rule 12, subsection 1, which goes into motions for support or allowances require a disclosure of financial condition. He goes into Local Rule 40, subsection 2, which talks about the fact that we're supposed to use a court-approved financial disclosure form. His next assertion is that the approved financial disclosure form requires an attachment of the 3 most recent pay stubs, and he is ordering that to be turned over. And here I attached a recent paycheck stub to the motion. However, neither of us filed a financial disclosure form. And then he goes into the next assertion, which is that a court's refusal to modify child support where an allegation of changed circumstances is not supported by evidence in the record. So he's just talking to, okay, so this is just him saying we need to file financial disclosure forms within 21 days, and that's it. Okay, and I guess there's no hearing set or anything like that. So maybe that happens at a later date, guys. Certificate of service by mailing, and he cites Rule 5. Moving on to supplementary points and authorities regarding child support modification. So I'm appearing, okay, wait a minute. Just a pretty big paragraph. What am I stating here? Purpose of the pleading is to make clarifications in response to the court's order to file financial disclosures. By the way, guys, I don't know why I'm doing it this way. You can't really do supplementary points and authorities like this. It's not a good idea. Maybe a better approach for me was to file another motion, possibly, or to ask the court if I could have permission to file like a cert reply or something like that. I don't think that would work either. Probably the best approach here would just be to wait until the hearing and just preserve these arguments for the hearing rather than file them in an extra piece of paper like this, because then my ex's attorney doesn't have a chance to respond to it. And in the event, guys, just letting you know, I probably wouldn't do this if I had the knowledge that I have now back then. I would just, kind of keep these in my mind and bring them up at the hearing is most likely what I would do. So, a lot of this looks like I'm just rehashing the previous arguments that I made. And I guess I'm just trying to force the court to stay on course with regards to the willful underemployment statutes in case. I don't know. I suppose it's possible that there were policy arguments in my ex's attorney's documents or in the judge's order. I can't remember now off the top of my head. If there were, it is true that you can't use policy arguments in the face of an unambiguous controlling statute. An unambiguous statute is a statute that's plain. The language is so plain that there's only one meaning that can be derived from it. And it is true that you can't use policy arguments to persuade the court when there's a plain, simple statute. You can do that when there are conflicting statutes or there's ambiguity, stuff like that. But yeah, I don't think that this was worth a filing. I shouldn't have filed this. And then I got my NRCP 5 certificate of service here as well, indicating that I personally served this upon my ex's attorney. Here is my financial disclosure form. I think my ex's will probably come up in one of the later videos in the series. This is going to have information that's very old from 2013, so I don't care if you guys have this information. This is another financial disclosure form. Guys, I'm going to just move through this quickly. If something jumps out at me, I'll talk about it, but we've gone over financial disclosure forms before. You just fill in all the dollar amounts. It looks like most of it I'm just going to skip over. As with my previous videos, you can always go down into the description below, click on the link, download the document for yourself, take a look, and if you have questions, you can post those questions down in the comments and I'll answer them to the best of my ability. But this is pretty simple stuff. It just goes through your bills, your expenses, your income, you put in the dollar amounts, your assets like your cars and stuff, your debts like your credit cards, student loans. Nothing here is really legal. So I'm not going to spend any time on it. We have Rule 5 certificate of service here as well, indicating that I served this document upon my ex's attorney personally as well. Here is a general this is an affirmation declaring under penalty of perjury to the clerk of the court that this document doesn't contain my social security number or the social security number of any person. List of exhibits. We're going to go into the paycheck stubs. Guys, we've gone through these before. Well, these are new paycheck stubs, I'm sure, but anyone knows what these look like. This is not a legal document. You can, of course, take a look at my pay stubs if you really care to back in 2013. I don't mind. All of this is old information. It's very important for me to stay as transparent as possible with a channel like this because my approach is educational. It's not revenge. It's not to attack the court system or my ex. I do have opinions that are very negative about both, but it's not the purpose of the channel. And so one of the things that I've always made sure to do is to be as transparent as possible. That's why I have the policy of showing every single filing and every single hearing video in all of my cases. Going into the aftermath, I filed, let's see, 1, 2, 3, 4 documents. They are all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney probably would have spent very little time on these documents. The request for submission, 1 minute. The supplementary points and authorities, I'm going to just say 1 minute. Like, she's not going to care about that. So we're at 2 minutes so far. The judge's order to file financial disclosures, she would have probably put 3 minutes into that and just told my ex, hey, prepare a financial disclosure form. So I'm going to put that up to 5 minutes. We got 2 more documents. The reply to opposition, she doesn't have to do anything. That's the end of the briefing schedule, or that's the end of briefing. And so I think it would be reasonable to say 10 minutes of her time would have gone into that. She's going to spend a lot more time at the hearing than she is just reviewing that paper for no reason at all. So that's going to take us up to 15 minutes. The general financial disclosure form is highly relevant to how she's going to approach the hearing. So I think still, it's not very complicated. It's not like I have multiple houses and cars. It's very basic. I have one job. I have paychecks. I have standard. The stuff in there is not at all that complicated. So I'm going to go ahead and say that that document is 15 minutes, which brings my ex's total to 30 minutes, which at the rate of $250 an hour comes to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.